Hi everyone, I'm Samidha Hegde. I'm interning with LEXIS and Company. I'm a third year law student studying in Ramaya College of Law, Bangalore. And today I'm going to be discussing the case of Lily Thomas versus Union of India, the 2000 judgment. This is with respect to bigamy. There are other cases in the same name, but the one I'm dealing today is with respect to bigamy. So under Muslim law, a man can have four wives. But the condition is that he has to treat all the four wives equally. But under any other personal law in India, bigamy or polygamy is prohibited, and also it is a crime. It is an offence under section 494 of IPC. So what happened in Lily Thomas versus Union of India? So in Lily Thomas versus Union of India, the facts of the case are there was this Sushmita Ghosh, a lady called Sushmita Ghosh, and her husband was G.C. Ghosh, Gyanchand Ghosh. So they were married for a few years, and in 1992, in the year 1992, after a few years of marriage, the husband told her, Sushmita Ghosh, that he's uh, going to remarry another woman called Vanita Gupta. Vanita Gupta was a divorcee with two children. He's going to marry her, and he's also converting to Islam for the purpose of that marriage, and that she should mutually agree for a divorce with him, because if she doesn't agree for a divorce, then she'll have to put up with a second wife. So after this, the petitioner, that is Sushmita Ghosh, she called up her relatives, her father and aunt, and explained them. They also tried to convince this G.C. Ghosh, but he was stubborn. He was not ready to change. So later a petition was filed. Uh, Petition was filed. So what were the issues in this case? The issues in this case were whether there should be a uniform civil code for all Indian citizens, and whether a Hindu husband can solemnize a second marriage by conversion to Islam, then whether the husband would be liable for bigamy under section 494 of IPC. So the petitioner's argument was that allowing a person to convert into Islam for the purpose of uh, converting to Islam and marrying, this is violative of Article 21 of the woman's fundamental right. This is violating her fundamental right, and therefore the petitioner sought that polygamy under Muslim personal law be held unconstitutional, and also it was also urged that a uniform civil code should be applied because there are many disputes and conflicts arising as a result of this separate personal laws, and also they said that several times women's associations have also come up to courts and requested the same. And as for respondent side, they maintained the same assertion throughout all the petitions, that a Muslim man can have four wives as permitted by Muslim personal law, irrespective of the fact that um, he was a Hindu, and his first wife uh, was also his first wife was a Hindu, and since after his conversion he is not subject to Hindu Marriage Act 1995, and therefore it will not be considered a bigamous marriage, and therefore they it will not attract section 494 of IPC. So what did the court hold? The court held that mere conversion does not bring to end the marital ties unless a decree of divorce was obtained on the was obtained. So what they said was, until and unless the first marriage has been dissolved or a divorce has been obtained, you cannot convert to another religion and marry another time before the first marriage has been dissolved. If such an act is done, that is while the first marriage is subsisting, in during that time if you enter into a second marriage without dissolving the first one by converting, then the second marriage will be held void and will be subject to section 17 of the Hindu Marriage Act, as well as it will attract the provisions of section 494 of IPC. And so this is what was held in the case, and I completely agree with the judgment of this case. And it is we hear of many such instances where men have converted to Islam only to bypass the law, that is to they are taking advantage of this loopholes in the law in order to remarry. This is done especially when the marriage cannot be dissolved on any of the grounds mentioned under section 13 of the Hindu Marriage Act. Let's say you do not have a reason that is provided under any of the grounds mentioned for divorce under Hindu Marriage Act. In that case, a lot of people resort to this second marriage by conversion, and this affect, and always women tend to be at the receiving end of such acts, because if the second marriage is not held void, then it affects the rights of the first wife. And if the second marriage is held to be void, then in that case it means that the second wife was not a wife, not a legally she was not a wife, and she will be construed as a concubine, and she will not be entitled to any maintenance, and also if she had any children, those children will be considered illegitimate. So either way it affects the rights of the woman. That is why I think we urgently need to uh, apply uniform civil code all over India, because uh, not just this, but there are various conflicts and disputes arising as a result of personal loss, and we have reached such a point in time where I think we should accept uniform civil code with a uniform law throughout the country for all citizens, so as to avoid all these conflicts. So yeah, that is my take on this case. And there were some further developments after the Sarala Mutkal judgment and also Lily Thomas versus Union of India. The Law Commission suo motu took up investigation into this matter, and they recommended that a new provision be inserted into all the personal laws, saying that a married person cannot uh, cannot even after conversion marry uh, until and unless the first marriage has not been dissolved, or a divorce has not been obtained. If they do so, it will attract the provisions of section 494 IPC. And the another recommendation was that if a marriage becomes interreligious, let's say two Hindus married, but after a while one of them converted, so in that case the marriage will become interreligious. So if the marriage becomes interreligious due to conversion by either of the spouse or a party, it will then thenceforth be governed by Special Marriage Act. Now, even if they did not marry according to under Special Marriage Act, even if they married under Hindu law or Muslim law, even then, if during the course of marriage one of them converts to a different religion and the marriage becomes interreligious, in that case from then on they should be governed by Special Marriage Act. So but this was not passed by the parliament. This was the report was presented but no action has been taken, so we are yet to see any change further in time. So that's all. I hope you liked today's video. I've also made several other videos, please do check them out. And don't forget to like, share and subscribe to the channel and press the notification button for more updates. Thank you.